The crackdown has begun. In June 2025, major immigration enforcement actions are underway across the United States. From expanded deportation quotas to visa denials and a possible new travel ban. These shifts affect millions, including green card holders, visa applicants, and undocumented immigrants. Many of these policies are already active. Some are under review, and others, like the proposed 36-country travel restriction, could be just weeks away. Let's break it all down in clear, factual terms so you know what's happening, what's changing, and how to prepare. ICE's 3,000 deportations per day policy. In one of the most aggressive enforcement updates in recent years, Immigration and Customs Enforcement (ICE) has been directed to process 3,000 deportations per day. This new daily removal target is not just a goal, it is currently in effect. Multiple attorneys and immigration reporters confirm that ICE is increasing detention capacity, prioritizing cases with final orders of removal, conducting more field operations in cities and transportation hubs. This initiative is tied to broader directives under current immigration enforcement policy. The emphasis is on speed and volume, not just targeting criminal cases. ICE funding crisis and emergency request. ICE is also facing a budget shortfall of over $1 billion. The agency has formally requested an additional $2 billion from Congress to support current operations, including staffing and enforcement costs, detention center expansions, a transportation and deportation logistics. Without additional funding, ICE may seek emergency powers to reallocate money from other departments. This situation adds financial pressure to the already expanded removal operations. It also highlights how resource-intensive the new 3,000 a day target really is. Green card holders. Re-entry concerns rise. There is no travel ban for lawful permanent residents, LPRs, at this time. However, re-entry screenings at airports and border checkpoints are becoming more detailed. CBP officers now spend extra time reviewing a length of time spent outside the U.S. pending applications like I-751 or N-400. Any criminal charges, even if dismissed. Signs of abandonment of residence. In recent weeks, multiple green card holders have reported being taken to secondary inspection, asked about their intent to remain in the U.S., issued notices to appear in removal proceedings. This doesn't mean every green card holder is at risk, but it's a sign that travel now carries more scrutiny than before. 36 countries under travel ban review. A leaked internal State Department memo reveals that 36 countries are being evaluated for possible visa restrictions or travel bans. These countries include several nations in Africa and the Caribbean, countries with high visa overstay rates, governments that delay accepting deportees, nations with weak ID verification processes. According to the cable, these countries have been given 60 days to cooperate. If improvements are not made, the U.S. may respond with suspension of new visa applications, halting certain categories, e.g., B1/B2 or F1, full travel bans in some cases. These changes could impact both current applicants and people abroad planning to visit the U.S. What is triggering visa denials? Attorneys report a sharp increase in non-immigrant visa denials. Even applicants with strong travel history or ties to the U.S. are being refused entry. Common triggers include past overstays even if resolved, suspicion of immigrant intent, social media content that raises red flags, a lack of documentation showing strong ties to home country. In some cases, no reason is formally stated, only a reference to INA Section 214B. If you're applying for a tourist, student, or work visa, it's important to prepare carefully. Supporting documents, clarity of purpose, and strong ties abroad are key. Sanctuary cities and enforcement zones. Cities like New York, Los Angeles, Chicago, and Atlanta are seeing increased ICE presence. These cities often have sanctuary policies, meaning local police don't enforce immigration law. But ICE still operates independently. Recent actions in these cities include street patrols in high-traffic areas, stops at transit hubs like bus terminals and subways, home visits in targeted neighborhoods. People in these areas should avoid carrying false documents, know their rights, refrain from sharing personal information unless legally required. Being in a sanctuary city does not mean you're fully shielded. It only limits certain types of local cooperation, supervision, court dates, and fast removals. Not everyone detained by IC is deported immediately. Depending on your case, you might be placed under IC supervision with check-ins, issued a notice to appear, and sent to court. Removed quickly under expedited removal policies. Some individuals are released if they have U.S. citizen children. They're the primary caregiver. They have serious medical conditions. Others are offered alternatives like ankle monitors or regular reporting. Still, many face court without legal help, which is why knowing your options is critical. Families with U.S. citizen children. Having a child born in the U.S. does not guarantee protection from removal. Even families with children in school or those with special needs can face deportation. You may apply for cancellation of removal if you've been in the U.S. for over 10 years. Your removal would cause exceptional and extremely unusual hardship to a U.S. citizen child or spouse. But this is a discretionary form of relief. It's not automatic. You must request it through the immigration court process. Visa overstays and unlawful presence. Overstaying a visa can lead to serious consequences, especially now. The most common affected groups include B1/B2 visa holders who didn't depart on time, F1 students who stopped attending school, workers on expired H1B, L1, or J1 visas. If you accrue 180+ days of unlawful presence, you may face a 3-year bar. 365+ days, it becomes a 10-year bar. Some individuals may not even realize they've triggered these bars. That's why consulting an attorney is essential if your status is unclear. Legal experts recommend these steps. Here are standard recommendations from immigration attorneys right now. 1. Always carry proof of status. A green card, EAD, passport copy, or visa. 2. Know your rights. You do not need to open the door without a signed warrant. You can remain silent and ask for a lawyer. 3. Prepare a safety folder. Passport copies. G. 28 signed attorney form. Birth certificates of U.S. citizen children. Medical records and school letters. 4. Stay updated. Policies are shifting weekly. Subscribe to reliable immigration sources like this one. Citizenship, the strongest protection. If you're eligible, applying for naturalization is one of the best steps you can take. U.S. citizens are not subject to deportation for most immigration issues. Citizenship also gives faster passport access, stronger protections at ports of entry, full voting rights. It may require a background check, English test, and civics exam, but the benefits are long-term. Final summary: what you need to know. Here's a full recap of the current June 2025 landscape. ICE is targeting 3,000 deportations per day. 36 countries may face visa bans. A green card holders face increased travel screenings. Visa denials are up, especially for B1/B2 and F1 applicants. Sanctuary cities are under new enforcement pressure. Overstays and past violations are being reviewed. Citizenship remains the most secure option. If you or someone you know is affected by any of these issues, consult a licensed immigration attorney. And stay tuned, because policy updates are rolling out fast. Thanks for watching BorderDrip USA. For more fact-based immigration updates, don't forget to like this video, subscribe to our channel, and turn on the bell icon so you don't miss the next alert. Thanks for watching. See you in the next video.